Hello everyone, welcome to our new topic and another lecture which is about the RA 9344 or the so-called Juvenile Justice and Welfare Act of 2006 under Unit 2 Bases and Policies of Special and Exclusive Education. Our national hero himself, Dr. Jose P. Rizal, once said that the hope of our nation is the youth, and the state recognizes the vital role of the youth, especially in building our nation's future. This is the reason why an amendment was created, which is the RA 9344. Now, let us take a look what is RA 9344. It is an act establishing a comprehensive juvenile justice and welfare system, creating the Juvenile Justice and Welfare Council under the Department of Justice, appropriating funds, therefore and for other purposes. Under RA 9344, we have the Juvenile Justice and Welfare Law. Republic Act Number 9344 or the Juvenile Justice and Welfare Act defines juvenile justice and welfare system as a system dealing with children at risk and children in conflict with the law, which provides child-appropriate proceedings including programs and services for prevention, diversion, rehabilitation, reintegration, and aftercare to ensure their normal growth and development. As an offshoot of the United Nations Convention on the Rights of the Child, the RA number 9344 intends to deal with these children without resorting to judicial proceeding instead of punishing juvenile offenders and treating them as criminals. These child offenders will be proved by the state and the community with assistance to prevent them from committing future offenses. Instead of using the word juvenile, Philippine laws made use of the word child. As defined in RA number 9344, child is a person under the age of 18 years old, while child at risk refers to a child who is vulnerable to and at risk of committing criminal offenses because of personal, family, and social circumstances. Some of the examples mentioned in the law are being abandoned or neglected, and living in a community with high level of criminality or drug abuse. Another is being abused by any person through sexual, physical, psychological, mental, economic, or any other means, and parents or guardians refuse or unable to give or provide protection for their child, coming from a dysfunctional or broken family or being without a parents nor guardians, and being out of school, being a street children, and being a member of a gang. Child in conflict with the law or CICL on the other hand refers to a child who is alleged as accused of or adjudged as having committed an offense under Philippine laws. So the major differences between child at risk and a child in conflict with the laws is that in the child at risk, there are instances that can possibly lead them to be delinquent, so they are at risk. From the word itself, they are at risk, so if they will engage in negative activities, thus are possibilities they will become vulnerable in the future. They are not yet considered as offender, but only a possibilities. While the CICL, they are already committed a crime, they already have a conflict with the law. Another is under RA 9344, we have Juvenile Justice and Welfare Council or JJWC. It is created and attached to the Department of Justice and placed under its administrative supervision. The JJWC shall be chaired by an Undersecretary of the Department of Social Welfare and Development. The JJWC have several duties and functions. To name a few, first is to oversee the implementation of this act, to advise the President in all matters and policies relating to juvenile justice and welfare, to assist the concerned agencies in the review and redrafting of existing policies, regulations, or in the formulation of new ones in line with provisions of this act, and many more. We can see the whole duties and functions of JJWC in Section 9 of RA 9344. These duties and functions of JJWC helps the government to achieve its goals in nurturing and protecting the youth for risk. Next one is Child Rights Center or CRC. The existing Child Rights Center of the Commission on Human Rights shall ensure that the status, rights, and interests of children are upheld in accordance with the Constitution and international instruments on human rights. The CHR shall strengthen the monitoring of government compliance of all treaty obligations and including timely and regular submission of reports before the treaty bodies, as well as the implementation and dissemination of recommendations and conclusions by government agencies as well as the NGOs and civil society. Now let's proceed to local councils for the protection of children. First is that it shall be established in all levels of local government, and where they have already been established, they shall be strengthened with 1 year from the effectivity of this act. Second, in here the local council shall serve as the primary agency to coordinate with and assist the LGU concerned to the adoption of a comprehensive plan on delinquency and to oversee its proper implementation. Lastly, the Sangguniang Kabataan plays an important role in this fight against juvenile delinquency. Sangguniang Kabataan shall coordinate with the LCPC in the formulation and implementation of juvenile intervention and diversion programs in the community. Let us now talk the principle in the administration of juvenile justice and welfare. So basically, if we will going to compare the juvenile offender to adult offender, both of them have rights, which is the right of an accused. So in similarities, they should not be both under into torture, deprived of liberty, and many more. And we can see it in RA 9344 Section 5. If they have similarities, they also have differences. So if we will going to see this juvenile justice system, they have this so-called diversion system. It is an alternative to determine what is the proper right and treatment for a juvenile accused. If we will talk about the minimum age of criminal responsibilities, which play a very crucial role in prosecution of CICL cases. So example, an offender is below 15 years old, she will be now exempted from criminal liability. After determining their ages and prove that they are below 15 years old, then they will be put into intervention program. Intervention program was created by the government or the juvenile justice system to determine what are the factors that affected a child for committing a crime. Example is, she committed a murder. That intervention system determined the factor behind why that child commit that kind of crime. So another is that the 15 years old above but less than 18 years old, so the same as 15 years old below, they are exempted from criminal liability and they will also put to intervention program. But now discernment will play a specific role here. If the child is proven with discernment, it is the time to have diversion program. Under the initial contact with the child, here are the procedures for taking the child into custody. From the moment the child is taken to the custody, the law enforcement shall first that it must be explained to a child in a simple language and in dialect that she can understand why she is being placed under custody and offense that she allegedly committed. Second, inform the child of the reason for such custody and advise the child of her constitutional rights in a language or dialect understood by him or her. Next, properly identify himself or herself and present proper identification to the child. Refrain from using vulgar or profane words and sexually harassing or abusing or making sexual advances on the child in conflict with the law. Another is that avoid violence or unnecessary force. Refrain from subjecting the child in conflict with the law to greater restraint than is necessary for his or her apprehension. Avoid displaying or using any firearm, weapon, handcuffs, or other instrument or force, or restraint unless absolutely necessary and only after all other methods of control have been exhausted and have failed. Another is determine the age of the child pursuant to Section 7 of this Act. Next, immediately but no later than 8 hours after apprehension, Turn over custody of the child to Social Welfare and Development Office or other accredited by NGOs and notify the child's apprehension. The Social Welfare and Development Officer shall explain to the child and child's parents or guardians the consequences of the child's act with a view towards counseling and rehabilitation, and so on. Next is take the child immediately to the proper medical health officer for thorough physical and mental examination. Another is ensure that should the detention of the child in conflict with the law be necessary, the child shall be secured in quarters separate from that of the opposite sex and adult defenders. Record the following in the initial investigation. Next is ensure that all statements signed by the child during investigation shall be witnessed by the child's parents or guardian or any social worker or legal counsel. A child in conflict with the law shall be searched by a law enforcement officer of the same gender and shall not be locked upon a detention cell. In short, RA 9344 or Juvenile Justice and Welfare Act is created to prevent children from being treated as criminals. Juvenile justice system is very important because it gives young offenders a second chance at life and to give them a better future. That ends our lecture for today, and I hope you learned something from our discussion. Thank you.